Hello, everyone, and welcome to today's podcast. I'm Harpreet Sidhu, a personal injury lawyer at Foisy Associates, and I'm joined by my colleagues, Russell Aloshi, Roger Foisy, Rutumi Tank, and Daniel Berman. The key considerations when deciding to settle your no-fault accident benefit claim. When you've been in a motor vehicle accident, deciding how to resolve disputes with your insurance company can be overwhelming. Do you settle on specific issues you disagree on, or do you settle the entire accident benefit claim? These are not decisions to be taken lightly, and we're here to help you understand the options available. Start with the basics then. Russell, what exactly is a settlement between parties in an accident benefits claim?
So settlement is essentially an agreement between you and your insurance company where both of you have come to a common understanding of how much a specific benefit or issue or how much your claim is worth. For example, you could settle one of your benefits, an income replacement benefit, or you could just settle your entitlement to that benefit for a specific period of time. But as well, you can settle the entire case where what you're doing in both of these instances is you're closing the door to accessing your benefits for that period of time. It's very, very important that you understand what you're doing before you enter into any settlement, because once you do so, it's final and it's quite impossible to gain access to the benefits again after you've settled.
Right, and that brings us to a very important distinction then, the difference between settling a single issue or settling your entire claim. Rutumi, maybe you can explain what are the differences between the two and ultimately the consequences.
Sure. When you and your insurer disagree on a specific issue, such as a denial of benefits, you can appeal that decision through the License Appeal Tribunal. Sometimes, after the appeal process starts, the insurer may offer to settle your entire case rather than just the issues in dispute. On one hand, you might be offered to settle your entire accident benefit claim, which means that all issues, past, present, and future, whether known or unknown at the time, are resolved in one go. The danger here is that you could be forfeiting future benefits if your injuries worsen or if new conditions arise. A better option in many cases would be to just settle the issues in dispute, meaning that you'll agree on the issues in dispute and leave the other parts of your claim open for future disputes or decisions.
And settling your case entirely is especially risky when dealing with injuries that may seem non-catastrophic at first, but could be deemed catastrophic later on. Russell, can you discuss the implications of settling an entire accident benefits claim when the injuries have the potential to worsen over time?
Well, that's a crucial problem at times. It's a more problematic when you are dealing with non-catastrophic injuries, especially because injuries tend to evolve over time and you are not certain how your impairments may proceed over your lifetime. For chronic pain and especially brain injury cases, these are some of the more complex ones to try and estimate how your future recovery will progress. So when you are settling your case on a full and final basis, what you're doing is you're essentially deciding what the value of your recovery is going to be up front. You're not allowing time to tell you what your progress is going to look like. And you are at risk, essentially, of leaving yourself not covered for a long-term recovery that these injuries may put you through. For example, your injuries may not be deemed catastrophic at first. However, over time, as your injuries progress, your injuries may indeed be deemed catastrophic. And that is a critical change because it will allow you to gain access to much higher benefits, a much longer timeline for your recovery, and as well as a much higher tier of financial support over the course of that recovery.
And that's a huge concern when insurance companies often push to settle an entire claim quickly. Daniel, can you explain why insurance companies want to settle entire claims rather than just individual issues?
Sure, and that's a common thing that we see with insurance companies. The goal of an insurance company is to limit their liability. And oftentimes they'll want to settle early and settle on a full and final lump sum basis because then they're basically off the hook. They don't have to pay for any future care needs, regardless of whether an injured person continues to deteriorate over time. So while a lump sum offer early on may seem attractive, be very careful because once you settle on a full and final basis for a lump sum claim, you're not protected in the future. In short, an early settlement may help an insurance company far more than it helps you unless you have a clear understanding of your future care needs.
And there's another major factor, cost. Roger, let's talk about the risks of going to a hearing, especially when it comes to the costs associated with retaining experts and how crucial it is to have a lawyer that's experienced in handling these appeals. Can you explain why it's important to ensure your lawyer has a track record of success with hearings at the LAT, especially for catastrophic impairment claims?
Absolutely. The cost aspect is often overlooked. When you go to a hearing, especially for something as significant as a catastrophic impairment determination, you'll likely need to bring in expert witnesses, neurologists, psychiatrists, or other doctors and rehabilitation specialists. These experts, they don't come cheap, and it's your lawyer's job to coordinate their involvement. If your lawyer isn't prepared to cover these costs for you up front or doesn't have a network of credible experts, it could weaken your case. Additionally, it's critical that your lawyer has actual experience handling catastrophic impairment cases at the License Appeal Tribunal. Not every lawyer has the skills or resources to take a case all the way through to a hearing. And some may push back just for a settlement because they aren't comfortable navigating the complexities or incurring the costs associated with a full hearing. You don't want to find yourself in a conflict situation where your lawyer would prefer to settle for a quicker result, even if it's not in your best interest. This is why you should always ask about your lawyer's experience with LAT hearings, especially for catastrophic cases. And don't forget their track record of success. It's important to know. You want someone who's not just willing, but is fully prepared to go the distance, if necessary.
Exactly. Having a lawyer with the right experience and willingness to see your case through a full hearing is crucial. Otherwise, you could be at risk of settling your case for less than what you deserve. And speaking of catastrophic impairment determinations, it's important to know whether your legal representative is even capable of handling such a case. Russell, can you explain why having a lawyer rather than a paralegal is critical in catastrophic impairment cases?
So yes, paralegals can handle non-catastrophic cases. However, unless they're being supervised by a lawyer, they cannot handle catastrophic cases on their own. Those cases are highly complex. They involve a lot of medical evidence, a lot of expert testimony. There's a lot of intricate legal arguments that need to be presented, and it's not easy for someone who doesn't have the requisite experience and training to do so. However, I think what becomes a more concerning topic that our listeners should be worried about is that an inexperienced paralegal may not know and may not recognize if your injuries are becoming or are worth a catastrophic designation. That's simply inexperience. In those cases, it's especially important to recognize that a paralegal is unable to really advise you on what you should do with your case. They may not actually be able to give you any proper next steps to follow and how you want to proceed with your case. An additional conflict that could arise is if they recognize your injuries could be catastrophic, but they have to cease representing you at this point because they're simply not allowed to continue handling your case on their own. And this creates an added cost for you because now you have to go and retain another lawyer.
Thanks, Russell, and that's a crucial distinction. Before we wrap up, I want to reiterate the importance of carefully considering any settlement offer, whether it's for a single issue or an entire accident benefit claim. I'm reminded of the various calls that our office has taken where the person has settled their entire accident benefit case and several months later realized that the injuries were, in fact, more serious and would require more time and treatment to recover. Unfortunately, their settlement appears to not have taken this into account. So take your time, seek proper legal advice, and make sure you fully understand the long-term consequences of your decision. Any final thoughts from the group?
So my final thought would be strategic and always consult with a lawyer who has the requisite expertise and knowledge to guide you through this complicated process.
And don't let insurance companies pressure you into settling your entire accident benefits case if you don't need to. Sometimes it's much more beneficial for you if you just settle one issue or a number of issues rather than settling the entire case.
And finally, ensure that you understand it is expensive to go to a cat-lat hearing. Ensure that you find the lawyer who can front load these expert fees and the amount of time it's going to take to go through an entire 5 to 10 day hearing. Not every lawyer is prepared to do so or can afford to do so, so ensure you ask those questions up front.
Thank you all for your insights, and thank you to everyone watching today. If you're considering settling your accident benefits claim or you have questions about your case, feel free to reach out to us at Foisy Associates. We're here to help you make the best decisions for your recovery and your future. Until next time, take care.